He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
The defense is basically asking, so just touching the shoulder for a second is now a crime. This is where legal language meets common sense. And they don't always agree.
By your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code. This law can't be like that. Alan, sir, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28, 2024, the officer came to a stop behind the defendant's vehicle, and the light turned green, and the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage, and standard sobriety tests were
0.192? That's more than twice the legal limit in most states. At that number, your reflexes aren't just slowed there on vacation.
administered. HGN 6 out of 6. The walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's eligible, Your Honor.
All right. How many prior DWIs does he have?
He has one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart, and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel, and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're going to have you wait for him now, but after today, I'm going to waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right. I'm going to have you sign a reset. I'll have you meet with Fleischer for bond conditions, and we'll just have you waiting back for Mr. Stewart to show up. Okay? Please.
Right this way.
You ready?
Yes.
Come on up.
Good morning, Your Honor.
Hey, how are you? Mr. Stewart, what's new?
Yes, sir. How was your New Year?
Great. We did PC on your case.
Okay.
We just did stand up. What's your guy's name again?
My last name is Allen, Your Honor. I would like to make an argument on PC. I don't know whether...
Absolutely. I'm always ready to hear it. So refresh my memory. What happened?
So in Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The defendant,
He had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there were other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there were other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously...
This is a classic to go vor. Defense says no harm, no foul. Prosecution says rules are rules. The judge? They're trying to figure out if this was a safe drift or a legal landmine.
Is in compliance with the law. The only argument that the state has made here, elucidated, is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of, the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information, and I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps he's, I don't want to speculate. And you're saying, well, maybe he did it because of this, but I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know.
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
Right, but you got to articulate facts as well, right? So, according to the statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we look at the statute for failing to maintain a single lane, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
Is it 545.460? Isn't that it?
Fleming, Hardin.
545.060, Your Honor. Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely, or that there was
Judge,
anything unsafe.
I also have the list of, where under Texas law where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic, to decelerate.
Let's do this. This is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go? Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time.
Yes, sir. Yes.
Right? And give you time to take a look more, so if you need to, you too as well, if you want to try to find case law. Let me just go through, because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure.
Just gonna meet with the sheriff's and prosecutor and have a discussion.
Good morning again.
Hey.
I wanted to reapproach regarding the PC on Mr. Allen's case.
Okay.
I know the state has emailed me some cases that they wanted to cite to.
Morgan.
Judge.
I don't know whether someone else wanted to speak to that.
Yeah.
Notice the subtle chess move here. They're not just arguing about what happened, but whether the officer wrote enough in the report to justify a stop. Paperwork can make or break a case.
If we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failure to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
No, but one of the things is there's an element of unsafetyness, right?
And Your Honor, there are other vehicles around. As the officer articulated in the dims, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the dims.
But I get it.
And then,
But where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
and furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder, and there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerk back, it implies that there is not one of those 7 reasons to allow another car to pass, to stop or park, or to accelerate before entering the main lane of traffic or decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute on the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that taking that into account with Hardin, which he veered out of, he failed to maintain a single lane with other vehicles around, provided enough of a community danger to allow the officer to perform that initial stop.
Man,
Where's the danger?
It would be the other vehicles present, Your Honor.
He doesn't articulate that, though.
He does articulate that there are other vehicles.
All he says is there are other vehicles.
That is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles within the vicinity for it to be a danger.
Right. In the case law,
You don't know if it's in the vicinity, though. All he says is that there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles. And that's so vague and conclusory.
Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough where there's other vehicles around to provide that additional threshold for failing to make a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate
Right.
there is a permissible reason.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that this defendant violated, which is veering onto the shoulder, he did not do so for one of the 7 permissible reasons, and thus the officer has reasonable suspicion to stop it.
You're veering. That is 545.060, right? Isn't that part of that's the weaving, right?
It's a different one.
Because you just said there's another violation of the transportation code.
Yeah, and it's under 545.058 is for entering the shoulder.
may I address the court, please, Your Honor?
Hold on, let me pull that code up. So that's 545.
.058.
The transportation code.
All right, let's see. That is driving on an improved shoulder. An operator may drive on an improved shoulder.
The prosecution's ace in the hole. Those 7 permissible reasons for driving on the shoulder. If none apply, they say it's game over. But that's only if the judge buys the unsafe part of the story.
To the right of the main traveled portion of a roadway if that operation is necessary and may be done safely, but only if to stop, stand, or park, to accelerate before entering a main travel lane of traffic, to decelerate before making a right turn, to avoid a collision as permitted by an official traffic device. Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense. That's their case. It says the exact, that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop Applee for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, I would like to, highlight these 2 cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the 4th Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is Is there an element of unsafetyness?
And
That's all I want to know.
To just address one point briefly, in the case law throw, they do say that really on an improved shoulder is not prima facie case evidence of an offense. However, if it states explicitly that the offense of illegally driving on an improved shoulder can be proven in one of two ways, either driving on an improved shoulder was not necessary part of achieving one of the 7 approved purposes which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to the 7 articulated purposes in the statute that are not present here. He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code.
He wasn't
This
just
law can't be like
It
that.
wasn't just announced, he went halfway in. So he veered halfway into the shoulder. It wasn't just like a little deviation. He said, the officer said halfway into the shoulder.
And there it is. No probable cause. Case takes a sharp turn in favor of the defense. That's the legal equivalent of winning the first big round in a boxing match.
And then jerked back into the lane. So he went out and then came back into the
So are
lane.
we supposing that that's like half a second of driving on an improved shoulder? Is it 1 second? Is it a minute? Is it?
Time should matter. I mean,
Because the legislature articulated 7 specific reasons why that would be permissible, and they wouldn't have.
If an old grandmother who is 70 years old is driving on a freeway and accidentally,
And but that would provide the minimal justification just to perform an investigative, a stop, just to investigate. It wouldn't be an arrest or anything like that. It would just be the traffic stop would be allowed at that point.
I don't know. I don't think that the officer wrote enough in the report. I don't think that the unsafetyness as far as, saying that there are other cars around, I just don't think that there's enough.
Yes,
All right,
Judge.
I'll find no probable cause.
Thank you.
Okay.